Hi, welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University School of Law, SOL. Certificate Program in Human Rights, CHR. CHR11 Human Rights, Evolution, Concepts and Concerns. Block-1Understanding Human Rights. Unit-2 Universal Declaration of Human Rights. 2.0 Objectives. This unit deals with the history, importance, contents and justification of Universal Declaration of Human Rights. After studying this unit, you should be able to times understand the historical importance of human rights, times why there is a need for human rights over and above the rights enshrined in the constitutions of different states, times ideas behind the Universal Declaration of Human Rights and various covenants on human rights, and times worldwide influence of human rights. 2.1 Introduction. To emphasize the importance of rights, adjectives like natural, fundamental, or human have been used in the long history of their development. 20th century has been described as the century of human rights because the concept of human rights became increasingly important in liberal democratic as well as in the socialist and developing countries, particularly after the Second World War. Today, virtually all states officially subscribe to some doctrine of human rights. The Universal Declaration on Human Rights, UDHR, and the subsequent covenants on rights recognized that individuals have certain rights and obligations over and above those set down in their own judicial and administrative system. UDHR accepted the fact that there are clear occasions when an individual has a moral obligation beyond that of his obligation as a citizen of a state, thus opening up a gap between the rights and duties bestowed by citizenship and the creation in international law of a new form of liberties and obligations. 2.2 Historical background. The need for human rights. You have read in the last unit that the term human rights refer to the concept that every member of the human race has a set of basic claims simply by virtue of his humaneness. These are rights claimed in respect of all human beings as human beings. They are said to be universal rather than national and are different from the legal rights. They are claims held to belong to everyone regardless of any real provisions that may or may not exist for him in a particular state. They are based upon the simple fact that a human being should not be forbidden from certain things by any government. They are inherent in human beings rather than in societies and states. They are called human rights because rights are no longer derived from the operations of natural reason but from what is called human. It is derived, for example, from the fact that a person who is malnourished, tortured, wrongly imprisoned, illiterate or lacking in regular paid holidays is not living in a manner appropriate to a human being. According to Macfarlane, human rights are those moral rights which belong to each man and woman solely by reasons of being a human being. These are possessed by the human being simply as human beings, irrespective of the fact that they belong to any state, society, race, or religious faith. 2.2.1 Human Rights and Natural Rights. The term human rights came into being in the 20th century. In earlier centuries, these rights were commonly spoken of as natural rights or rights of man. The theory of natural rights emerged in the 17th century in the writings of Grotius, Hobbes, Locke, etc., who attributed natural rights to the natural law which provided that no one ought to harm another in his life, health, liberty, or possessions. That law could therefore be said to give each person a natural right to life, liberty and property, though it also imposed upon each a natural duty to respect the lives, liberties and properties of others. The theory got its classical expression in the writings of Johari Locke in his book The Two Treatises on Government. Locke termed the rights to life, liberty and estates as natural rights. Similarly, the American Declaration of Independence in 1776 enunciated as self-evident truths that all men are created equal and they are endowed by their Creator with certain inalienable rights, that among them are life, liberty and the pursuit of happiness. Again, the French Declaration of the Rights of Man and Citizens of France in 1789 made similar claims in relation to the natural, imprescriptibly and inalienable rights that it enumerated. In short, all these declarations emphasized upon the rights of man as man and not as a citizen of a state. 17th and 18th centuries' declarations of natural rights were matched in the 20th century by the Declaration of Human Rights by the United Nations and the various other UN covenants and conventions that followed. The human rights, thus, are the direct descendant of the theory of natural rights. The human rights introduced immediately after the Second World War by the newly formed United Nations were a direct consequence of the revulsions against the genocidal policies followed by the Hitler regime. These revulsions led to put a number of German leaders on trial for an offense that had no place in any statute book but was created by the decision of the International Court. The offense was called crime against humanity. The Nuremberg Trials Tribunal laid down for the first time in history that when international rules that protect basic humanitarian values are in conflict with the state laws, every individual must transgress the state law. The legal framework of Nuremberg trials challenged the principle of military discipline and subverted the national sovereignty. However, the contemporary international law endorsed the position taken by the tribunal and affirmed its rejection of the defense of obedience to superior order in matter of responsibility for crimes against peace and humanity. As a standard for the future, a special committee of the United Nations drafted a Declaration of Human Rights in 1948, followed by the two covenants, one on economic, social and economic rights, and the other on civil and political rights, which were recognized by the member states of the UN. Thus, having come through the harrowing experience of interwar totalitarianism and the horrors of the Second World War, the post-war international community set its human rights agenda through the Universal Declaration of Human Rights. Since then, the record of state behavior became subject to scrutiny through the standard of UDHR 2.3 Universal Declaration of Human Rights. The Comprehensive International Bill of Human Rights consists of three instruments: I. The Universal Declaration of Human Rights; 2. The International Covenant on Economic, Social and Cultural Rights; and 3. The International Covenant on Civil and Political Rights and its optional protocol. The Universal Declaration of Human Rights, UDHR, represents the first and the most important instance of formulation of international human rights standard. In fact, much of the international norm-setting activity of the United Nations flows from and relates to UDHR. It was adopted and proclaimed by the General Assembly of the United Nations on 10 December 1948 as a common standard of achievements for all peoples and all nations, to that end that every individual and every organ of society shall strive by teaching and education to promote respect for these rights and freedoms, and by progressive measures, national and international, to secure their universal and effective recognition and observance. 2.3.1 Objectives of UDHR. The preamble of UDHR makes it clear that it was a simple testimony to the fact that it was the first normative response of the then international community to the terrible experiences it had during the Second World War. It noted that disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind. It emphasized that recognition of the inherent dignity and of equal and inalienable rights of all members of the human family is the foundation of freedom, justice and peace in the world. It also stressed that a common understanding of human rights and freedoms enshrined in the UN Charter is of greatest importance for the full realization of the pledge. This was reflected in Article 1, which reads as, "All human beings are born free and equal in dignity and rights. They are endowed with reasons and conscience, and should act towards one another by a spirit of brotherhood." It defined the basic assumption of the declaration that the right to liberty and equality is man's birthright and cannot be alienated, and that too, because man is a rational and moral being, he is different from other creatures on earth and therefore entitled to certain rights and freedoms which other creatures do not enjoy. Similarly, Article 2 set out the basic principle of equality and non-discrimination as regards the enjoyment of human rights and fundamental freedoms, and forbids distinction of any kind such as race, color, sex, language, religion, political and other opinion, national or social origin, property, birth and other status. 2.3.2 Nature of UDHR. The UDHR contains a long list of human rights that belong to all human beings. These in general are categorized as civil and political rights and economic, social and cultural rights. Article 3 provides the right to life, liberty and security of persons as a right essential to the enjoyment of all other rights. This is expanded in Articles 4 to 21 in certain civil and political rights such as freedom from slavery and servitude, freedom from torture or cruel, inhuman or degrading treatment or punishment, the right to recognition everywhere as a person and before the law, the right to an effective judicial remedy, freedom from arbitrary arrest, detention or right to a fair trial and public hearing by an independent and impartial tribunal, the right to be presumed innocent until proved guilty, freedom from arbitrary interference with privacy, family, home or correspondence, freedom of movement and residence, the right of asylum, the right to nationality, the right to marry and to found a family, the right to property, freedom of thought, conscience and religion, freedom of opinion and expression, the right to peaceful assembly and association, the right to take part in the government of one's country, and to equal access to public service on one's country. Apart from the civil and political rights, the next 6 articles specify certain economic, social and cultural rights such as right to social security, the right to work, the right to equal pay for equal work, the right to rest and leisure, the right to a standard of living adequate for health and well-being, the right to education, and the right to participate in the cultural life of the community. These rights were considered as indispensable for human dignity and the free development of personality and indicated that they were to be realized through national effort and international cooperation. 2.3.3 Importance of UDHR. When the UN General Assembly adopted UDHR in 1948, it only intended the declaration to be a common standard of achievement for all peoples and all nations. However, 60 years after the declaration, one finds that it still stands as the single most important normative act ever adopted by the United Nations, for a number of reasons. First, having come through the harrowing experiences of interwar totalitarianism and the horrors of the Second World War, the post-war international community set its human rights agenda through the declaration. Since then, the record of state behavior became subjected to scrutiny through the standards set by UDHR. Second, although the declaration did not proclaim itself to be legally binding, it acquired such a character in 2 ways. It came to be regarded as an interpretation and elaboration of the UN Charter provisions on human rights. Its influence on The drafting and practice of state constitutions which came into existence after 1948 has been extremely impressive and far-reaching. The founding fathers of the Indian Constitution too were influenced by UDHR. Indian courts still use the Declaration to interpret and clarify the fundamental rights provisions of the Constitution. Third, UDHR provided the normative basis for all future activities of the United Nations in the field of human rights. It led to the drafting of two international covenants on human rights in 1966, both of which, along with UDHR, constitute the International Bill of Rights. The diverse provisions of UDHR inspired the eventual drafting and adoption of a large number of treaties and further declarations on specific aspects of human rights. In fact, almost all the United Nations human rights instruments that have emerged so far are in some way or the other based on UDHR. Fourth, the declaration also inspired efforts at the regional level for evolving human rights institutions. Its influence on the European Convention for the Protection of Human Rights and Fundamental Freedoms of 1950 and the institutions established under this treaty, such as the European Commission of Human Rights and the European Court of Human Rights, has been very significant. The Charter of the Organization of African Unity, 1963, also acknowledges its influences. However, we cannot overlook the fact that UDHR reflects what was essentially a mid-century Western perception of human rights, a response to the interwar and wartime European experiences. An international community dominated by the Western countries adopted it. The presence of the Third World countries of Asia, Africa and Latin America started being felt at the United Nations only from 1960s. Till then, their human rights problems did not receive as much serious attention at the United Nations as they deserved. This has led to a debate with regard to both the theories of human rights as well their universality. 2.4 Critique of human rights. Although the concept of human rights has been quite popular after the Second World War and has been universally accepted by the international community by adoption of UDHR, yet it has raised a number of objections ranging from philosophical, legal to ideological. Altogether, they have led to the question of how far human rights are justified. The opponents of human rights have dismissed them as no more than merely a set of prejudices, while the natural rights were justified on the basis of natural law. The concept of human rights has been detached from natural law thinking. Contemporary political philosophers justify a case for human rights upon the commitment to fundamental values such as freedom, autonomy, equality, and human well-being. However, the issue of human rights is a complex one because of the diversity in the socio-economic, political, and cultural differences among the states. In fact, in spite of their popularity, the human rights are far from being universally accepted. In some cases, they are rejected on a general critique of the rights approach to politics, whereas in others, the criticism is directed against the specific human rights. Some of the important points of criticism are as follows. 1. The first objection is the philosophical basis of human rights and its utility. The assertion that human rights inherent in all human beings is clearly a very sweeping statement irrespective of faith. The Universal Declaration is based on a political commitment by the founding states of UN but raises questions about why the governments of those states at that moment of history should have the power to commit the successor states despite numerous changes of regimes. It must presumably be based on reason or an appeal to common understanding about the human situation, but that raises the familiar philosophical dilemma about how values, Particularly, values said to be binding can be extracted from facts. All governments might agree that human beings seem to enjoy freedom of action in this field or that, without agreeing that it is good for them to be given such freedom. In short, the philosophical argument for the Declaration is shaky. As for the utility of the Declaration, many states are dictatorial, and the Declaration has not deterred most of those regimes from violating several of the human rights specified. It might be said that appeals to the Declaration have been at best as empty gestures, at worst a weapon in the Cold War. Moreover, it has failed to bring the violators of human rights before some Nuremberg-type tribunal, difficult because Article 11 states that no one shall be held guilty of any penal offense on account of any act or omission which did not constitute a penal offense under the national or international law at the time when it was committed. 2. The second objection is the legal one. Followers of Benthamite tradition claim that the human rights are asserted as though their existence is as much a matter of fact as the existence of legal rights. There is a fundamental difference between legal and human rights, and if this distinction is recognized, then human rights are no more than a moral claim. 3. The social, economic and cultural rights such as right to education, work, social security, rest and leisure, and an adequate standard of living, though not completely unprecedented, have become prominent within the human rights. But they have raised doubts not only about social justice but also about their intelligibility as human rights. For example, Maurice Cranston says that the economic and social rights are of little relevance because they are no more than utopian ideals for the poorer states, and their inclusion may lead skeptics to regard the other rights also as utopian ideals. Similarly, Brian Barry has also questioned the inclusion of social rights because they involve relativities about which arguments are always possible. A number of underdeveloped and developing countries do not have the resources to provide the goods. It is awkward to tell people that they have rights which cannot be provided, while on the other side of the globe, there are people who are enjoying them for a long time. Hence, they become different standards for different people. The other questionable feature of socio-economic rights is that for any specific person, the corresponding obligation to provide the goods falls upon the particular government. The right to have that good depends on citizen of a particular state rather than a member of the human race. Again, whatever the intention of those who have drafted Declaration of Rights, it is not logically nonsensical to hold that human beings have a responsibility on a world scale for the another's economic well-being. Some countries believe that the statements in the UDHR are based on a very modern Western way of life and thinking. They go on to argue that other cultures, like ancient tribal cultures or Oriental cultures, have customs that may clash with the ideas and the articles given in the Declaration. The culture-dependent debate shows up in different ways. Sometimes it takes a religious garb, for example, that human rights are Christian values and therefore not valid in Islamic states. Sometimes the debate is in the garb of Asian cultures versus European nations, as the following discussion shows. In Hindu philosophy, dharma is perhaps the closest word to human rights. Actually, dharma has many levels of meaning: law, norms of conduct, truth, rights, ritual, justice, morality, destiny, religion, and more. Vasudhaiv Kutumbakam, the world is our family, is the underlying philosophy. In particular, this philosophy says that rights are not confined to human alone, animals and plants also have such rights. In fact, this is part of the Jain philosophy too. Human rights are not rights only, they are also duties, and both are interdependent. as we have discussed in Unit 1. As you can see, Hindu philosophy looks at society and the universe as a whole. This differs from the Western view of the individual-based notion of human rights. In fact, most Asian societies reject the individualistic approach to human rights. The Buddhist doctrine, for example, does not accept the concept of life based on the self or ego. It emphasizes the holistic nature of things. If you look at studies of African and Latin American cultures, you will find the same stress on group rights rather than the rights of individuals. Another source of major differences involving community rights versus individuals' rights is the right to own private property. The UDHR has listed this as an individual's right. This has met with strong opposition from societies in which property belongs to the community as a whole. According to them, the Western world is trying to impose free enterprise and capitalism on the rest of the world by calling property ownership a fundamental human right. In fact, there is a very strong feeling in all these cultures that it is more important to improve the quality of life of the social group as a whole, rather than that of individuals. Giving priority to individuals is thought of as creating a selfish, aggressive and competitive society. What you have just read is a cross-section of views on human rights in different cultures and traditions. Would you agree that the Third World's views are clearly against human rights based on aggressive individualism? Think about this. 2.5 Universality of human rights. It has been mentioned above that the Universal Declaration of Human Rights was accepted by almost all member states of the United Nations organizations. From it appears that the ideas and nature of rights contained in the UDHR are universally accepted. The fact, however, is that in spite of UDHR there are differences of opinion among states with regard to nature of rights and their universality. 2.5.1 Cultural differences. A number of socialist and developing countries have objected to the universal character of human rights, thinking that they lead to cultural imperialism of the West. They claim that the Western societies are imposing their value system on the other cultures. For example, the Western idea of free speech may not be relevant to an illiterate, unemployed, or starving individual. Hence, employment, food, shelter, education may be more important than political rights and civil liberties in a particular state. Some states have also used this idea as an excuse to curtail the civil liberties. Anyhow, according to this view, if the individuals the world over must be accorded human rights, then that may be seen as granting a license for the domination of European culture over other cultures which do not share its conceptions of good life and just society. Also, the concept of human rights as developed in the West ignores the rights of the groups such as classes, nations and races. Ideas of liberty, democracy, though good, have paid too little attention to the concerns of class exploitation, national self-determination and racial discrimination. 1.5.1 The East Asian Challenge. The opposition to the UDHR discussed above has gained force in recent years. It is known as the Asian Values Debate or the East Asian Challenge because the arguments are mainly put forward by China, Indonesia, Malaysia, North Korea, Iran, Singapore, etc. In fact, the Bangkok meet of the NGOs on the eve of the Vienna Conference and their Declaration on Human Rights in 1993 is usually considered to be the beginning of the East Asian Challenge. Extending the debate, Professor Panikkar, a human rights philosopher, argues that the notion of human rights is a Western concept. Yet he also argues that these human rights are very necessary for a decent life in the modern world. What he and Other scholars believe is that these rights need to be adopted and adapted to different cultures. Regarding this matter, the Bangkok NGO Declaration stresses that the world can learn from different cultures and draw lessons from the humanity of these cultures to deepen respect for universal human rights. Different cultures should be allowed to coexist and their positive aspects must be respected by all. But, the declaration goes on to insist, those cultural practices which go against universally accepted human rights, including women's rights, must not be tolerated. As an example of adaptation, the Islamic Council of Europe, London, prepared a document called the Universal Islamic Declaration of Human Rights, UID. This is based on the values and principles of the Quran and the Sunnah. Like the UDHR, the UID also recognizes the right to privacy, the right to freedom of movement and residence, the right to use one's own culture and the right to freedom of religion. In this context, it is interesting to learn what Muhammad Kamli gathered from a brief survey. He found that even though Muslim jurists never articulated a precise definition of human rights, Islamic law was not only cognizant of those rights, but it even developed other more comprehensive and precise concepts such as hukum, order or legal decisions of God, which subsumed the former. In the following section you will have the opportunity to learn a little more about ancient traditions and what they have to say about such humanitarian objectives. The major points highlighted below have been taken from Professor B. K. Roy Berman's research. Times the Rock Edicts of Ashoka, in the 3rd century BC, proclaim the emperor's concern for the well-being of the hill dwellers. This line of thinking, which shows concern for the disadvantaged people, runs through all the ages and has produced bold advocates like Jyotiba Phule, Periyar and Ambedkar in the recent years. Manus Mehta forbade the king from misbehaving with the wife of the defeated enemy. In various chapters of the Quran, female infanticide has been condemned, and freeing a slave has been praised as an act of great merit. In fact, the Prophet himself had hundreds of slaves freed and allowed, after conquest, Christians and Jews to pursue their own faith. Times in China, Confucius laid the foundation of ethics in social relations. Chinese cultural traditions emphasized the importance of living together with dignity and happiness. Times ancient Roman laws required minimum horror of the sword to be sued to conquer enemy. Christian churches in early days prohibited the use of crossbow in war as it was deadly and odious to God. Times in tribal societies, even today, rape of women is unheard of. 2.5.3 Use and misuse of cultural relativism. Let us now go back to the cultural relativists. There is one important aspect of the issue that we have not yet discussed. Can this argument be misused by people for their own ends? For instance, if we are talking of Asian values, who was upholding these values when the Chinese government shot down hundreds of students demonstrating for democratic rights in Beijing? Were the students less Chinese than the rulers? Often ruling classes indulge in their power games under the guise of culture. People in power use the cultural relativism argument to justify political repression and restriction of rights. Of course, this is not always so. In Japan, the people chose to exercise their political rights according to their culture and opted for a one-party system without any force by the government or by law. It should now be clear that there are various dimensions of cultural relativism, and for a better understanding it deserves close examination. 2.5.4 Ideological differences. The traditional Western emphasis on individual liberties and political rights has met with objections and skepticism from the socialists and the Marxists as well. The Marxists, for example, stress that along with liberty, equality is also an important human value, and they regard the liberal notion of individual rights as a bourgeois illusion. They point out that the substantial inequality in income, effect, quality of life and power that exists in many liberal capitalist societies. The gulf between haves and have-nots is often very wide in these societies. Thus, the Western concept of human rights merely promises to everyone an equal chance to be unequal, i.e., to become richer than his or her neighbor. Again, the promise of equal opportunity is in reality a myth because power, wealth, and expertise are concentrated in a few hands. This concentration gives the elite control over the masses and allow a minority to exploit the majority. Finally, the Marxists argue that the interest of the society must override the rights of the individual. 2.6 How universal are human rights? What you have just read is that certain cultural traditions and practices are not in line with the views projected by the UDHR. At least, that is how it appears. But there is a little known fact which is, however, of great importance. Before creating the UDHR, the UN appointed a committee to see which, if any, human rights were considered fundamental by the different cultures of the world. The committee sent a detailed questionnaire to philosophers, historians, politicians, and thinkers around the world. Replies came in describing what different cultures consider to be human rights. How came the surprise? They found that the list of basic rights and values that they received from all these diverse cultures were essentially similar. For instance, the basic right to life is a value shared by all cultures. So, all the cultures would agree that most of the rights listed in the UDHR are necessary for a decent, dignified way of life. It is only a question of how each cultural group interprets these rights. The difference lies in this aspect. The different human rights cannot be separated from each other. They form among themselves a harmonious whole. It is the universal harmony that ultimately counts. The first paragraph of the Vienna Declaration states without ambiguity, the universal nature of these rights and freedoms is beyond question. The whole of the fifth paragraph is devoted to this question which, in the words of the Declaration, states, all human rights are universal, indivisible and interdependent and interrelated. The international community must treat human rights globally in a fair and equal manner, on the same footing and with the same emphasis. While the significance of national and regional particularities and various historical, cultural and religious backgrounds must be borne in mind, it is the duty of states, regardless of their political, economic and cultural systems, to promote and protect all human rights and fundamental freedoms. These provisions of the Vienna Declaration lead to the following conclusions. Times they state once and for all that dignity is the common basis of all human rights. Times they proclaim the universal character of those rights. Times, however, important to note is a need for taking note of national and regional peculiarities and of various historical, cultural and religious heritages as we accept the universal nature of the human rights. We live in a period of civilization in which human rights have received recognition through universal instrument, international human rights organizations and in some countries through national constitutions and commissions. It is gradually being recognized that man is born free and is endowed with certain universally claimed human rights. However, the paradox of contemporary times is that everywhere such rights are being violated or ignored. Humans without rights are on increase. Blood and tears and trauma and misfortune claim victims everywhere. Human inhumanity takes many forms. Social divisiveness and political instability, coupled with different institutional framework and inadequate resources, make it impossible to comply with the requirements of UN Declaration. It is argued that either human rights laid down by UN are too valuable to make it possible to establish what constitutes a right violation, or that they require to be interpreted by reference to the particular value or tradition of a particular society. Most of the rights are defined primarily in terms of civil liberties and political rights in the liberal democratic framework. The citizens of Western liberty democracies generally enjoy these rights and liberties, while the erstwhile socialist countries had criticized the nature of human rights from the beginning. The underdeveloped countries, social and political dislocation caused by the process of nation building tended to reduce the government's observance of human rights, as defined by the UN Declaration. The development of liberal democratic institutions usually occurred in societies with high level of communication, urbanization and per capita income. Thus, certain minimum level of socio-economic development is necessary for liberal democratic values and institutions to take hold in a country. Thus, socio-political structure of underdeveloped societies has been usually too fragile and inflexible to maintain the level of human rights. As a result, millions of people are being deprived of basic and minimum human rights. Although there have been sharp differences between liberal and socialist countries about the nature of human rights during the Cold War, yet the profile of human rights has changed in the post-Cold War era, and the UN has emerged as a significant institution to evolve human rights standards. The 1993 World Congress on Human Rights in Vienna noted, "The promotion and protection of all human rights is a legitimate concern of all in the international community." Of late, the UN has taken steps to protect the rights of people through the use of humanitarian intervention in countries like Iraq, Somalia, and Bosnia. It also established tribunals charged with the indictment and persecution of individuals accused of crimes against humanity and genocide in the former Yugoslavia and Rwanda. 2.6.1 Worldwide influence of the UDHR. Soon after the declaration, the issue of human rights began to be persuaded vigorously throughout the world and gradually attained a status of a movement. While the Western democratic countries saw in the human rights a vindication of the liberal capitalist ideology and a weapon to fight the Cold War, the ex-colonial countries of Asia and Africa saw in them an opportunity to get rid of their old feudalistic systems and a necessary tool for their development. The idea of human rights was propagated by a number of regional organizations, which provided separate conventions and covenants for the enforcement of human rights and fulfilling the gap left by UN. For example, a more marked reaction in favor of human rights was seen in Europe, not only because of its memories of the atrocities of the Nazis and fascist rulers, but also because the democratic Europe lived very near the communist USSR, whose outlook negated all the conclusions of philosophy which had led to the Universal Declaration of Human Rights. The Congress of Europe at The Hague in May 1948 announced its desire for a Charter of Human Rights guaranteeing the liberty of thought, assembly and expression. It was followed by a European Convention for the Protection of Human Rights and Fundamental Freedoms signed in November 1950. The Convention guaranteed the right to life, liberty, security of persons, of a fair trial, to respect for one's private and family life, home and correspondence, to marry and found a family, freedom from torture or inhuman treatment or punishment, freedom from slavery and servitude, freedom of thought and expression, conscience and religion, and freedom of assembly and association. Subsequently, right to property, to free election, right of parents to educate their child in conformity with their beliefs, freedom from imprisonment for debt, freedom from exile and prohibition of collective expulsion of aliens were also added. In marked contrast to the UN declaration, the European Convention was to take the first step for the collective enforcement of certain rights of UN declaration. Similarly, across the Atlantic, the Latin American states established an American Organization of States, OAS, in 1959. The various articles of this Charter of OAS held the states responsible for protecting human rights. An American Convention on Human Rights was signed by Chile, Colombia, Costa Rica, Ecuador, El Salvador, Guatemala, Honduras, and Nicaragua, Panama, Paraguay, Uruguay, and Venezuela in 1969, which came into force in 1978. About these regional instruments and arrangements you will read more in Units of Discourse. In 1960s, when the winds of change were blowing across Africa, the leaders of the African states formed the Organization of African Unity, without South Africa, and proclaimed the right of the people to self-determination. It prepared a draft of an African Charter of Human Rights and People's Right, 1981, and worked hard to establish bodies to provide, promote and protect human rights. The OAU has successfully performed. It covers people's rights known as group rights or collective rights. It too has a commission which examines the periodic reports from state parties on their complaints within the provisions of the Charter and established dialogue with the state representatives aimed at encouraging states to implement their human rights obligations. The OAU has been successful in bringing apartheid to an end. The experience of the European, Latin American, and African countries proved an encouraging example for the countries of Southeast Asia also. But such progress could not be made because of certain factors such as lack of political rights and civil liberties, lack of democratization and multi-party system, self-serving constitutional process, excessive national security laws, preventive detention and constraints upon due process of law, extensive limits on freedom of thought, expression and assembly, a compromised and defective judicial criminal system, unbalanced development, inadequate social safety nets, etc. Still, some regional initiatives have been taken to the direction of human rights, such as the Non-Aligned Movement, the Association of Southeast Asian Nations, and the United Economic and Social Commission for Asia and Pacific, and South Asian Association for Regional Cooperation. The landmark achievement of the ASEAN is a treaty signed between it and EC, in which ASEAN expressed its willingness to work for the betterment of human rights at regional level. Nearer home, SAARC formed with a strong signal for human rights awareness. It has been fighting against terrorism and human rights violation and hope to adequately respond to these challenges. Also, national human rights institutions in the form of human rights communities and commissions have also been set up in countries like India, Philippines, Indonesia, Sri Lanka, etc. 2.6. 2 NGOs on human rights. Apart from the regional organizations and human rights commissions at national levels, a number of non-governmental organizations have also come into existence throughout the world to keep a watch on the national governments with regard to any possible violation of human rights on the one hand and to promote and protect the human rights awareness on the other. Some of the NGOs of international fame are International Commission of Jurists, the International Federation of Human Rights, Paris, the International League of Human Rights, NY, and the Minority Rights Group, London. All these organizations have a special consultative status with UN. Two other important NGOs of international recognition are the Amnesty International and the Human Rights Watch. The Amnesty International was established in 1961 and its main thrust is to secure immediate and fair trials of political prisoners. It seeks an end to torture, execution, disappearance, arbitrary killings, hostage-taking and other inhuman, cruel or degrading treatments and punishments. The Human Rights Watch was established in 1987 in New York and it has more than 8,000 members. It evaluates the human rights practices of governments in accordance with standards recognized by international law and agreements and UN declarations. It identifies governmental abuses of human rights by monitoring. Unit of this course provides detailed information about the nature and role of NGOs engaged in the task of protection and promotion of human rights. 2.7 Summary. In this unit we have studied the issue of human rights both as a concept and as propounded by the United Nations. We have seen that in spite of the fact that rights are granted in the constitutions of various countries, the need for universal human rights over and above the state laws was acutely felt, particularly after the Second World War, due to certain crimes committed against humanity. The lead for this was given by the UN Declaration of Human Rights in 1948, which was followed by the two covenants, one on economic, social and cultural rights, and the other on civil and political rights, which were adopted in 1966. This was followed by a number of regional conventions such as the European Convention, the African Charter of Human Rights, the OAS Convention on Human Rights, etc. The issue of human rights became a worldwide phenomenon in the post-war period and it caught the attention of both the developed and the developing countries. A number of international NGOs and local organizations also came into existence almost in every country to promote and protect the human rights of people. These organizations have done splendid work in securing the rights of the ethnic minorities, refugees, children, victims of gender bias, bonded labor, mentally disabled, prisoners under trials, etc. It is not that the efforts of these organizations have removed cruelty and inhuman behavior from the face of the earth. Too many people still lack the simplest necessities of life and may still be deprived of the most basic human needs. But the upholding human rights are to reverse the process of human suffering and to restore the dignity of the individual. Thank you.